Yeah, thank you. Thank you to the Planet PA. Thank you, Melanie. Thank you, Christine. It's wonderful. Bruce and I appreciate your time tonight, and we're scheduled for about an hour. We're planning to leave time for questions at the end, but please, like we were just saying, go ahead, interrupt, raise your hand, write something in the chat, and we'll just kind of keep monitoring that. Bruce and I are both going to talk this evening. Our topic, alternatives to guardianship. We're going to take a very few minutes in the very beginning just to review the major big points of guardianship so that we can contrast with all of the odds and ends of alternatives, and then we can just better compare. So the world of special needs planning, Bruce and I, Bruce is the founder of, you can see, oh, move your head just a little bit so we can see it. There we go, Special Planning Solutions. I joined his company about a year and a half ago when I moved here. I'm Susan Walter, Bruce Sham. We are not new to special needs. We are both parents of adult children with special needs. Bruce is in kind of one part of the world, intellectual disabilities. I tend to be in the other part of the world. My son has very impactful epilepsy, and so we tend to be more in the medical part of the world, but we kind of cover the whole of everything. But we walk in your shoes, so we definitely get it. And we know there are so many more moving parts than traditional, life planning, retirement planning, financial planning. And it can feel really complicated, especially when some of the information is new or newish. You're learning that you also have to make lots of new decisions that you never imagined, just because of the new information. And even, just the acronyms, it's a lot sometimes. So we have to start somewhere. So a common goal of our clients, right, is to safeguard future security for our adult child or loved one with a disability or a special need. And that sounds good, but what are we talking about specifically? So finances, of course, are a big one. Housing security, meeting medical care needs. Who else in our orbit of family friends is able and available to make decisions? Let's not forget some of the emotional needs, the social needs of our people. So I'm going to kind of say the multi-billion dollar, used to call it the $1 million question, but we need to make it bigger these days. A million isn't as much money as it used to be. So the multi-billion dollar question is, what keeps us up and awake at night? What happens when we're no longer here to make those decisions and manage the care and support our person? If you're at all like I was maybe 15, 20 years ago, I went on this path. I was overwhelmed by the landscape, right, of trying to make sense of
I think she froze.
how and where and how. I froze?
You did for a minute.
Am I back?
Yep.
Okay, I was just saying I used to be overwhelmed, and then I got going and I learned things and I found people. And then I discovered that, even though I could be like a smarty pants and do a lot of research, I still needed other people to help me understand a lot of the nuances of a lot of this information. And these are ongoing long-term relationships, and we have to sort of be comfortable with all the new people in our lives that are helping us on this kind of village journey or whatever. So I guess is any of this true for you as you start thinking about it? And a metaphor, I'm working on this one. I'm like a comedian. I'm going to try out some new material on you tonight. A metaphor that I've come up with to kind of visually represent and explain the decisions and the coordinations and the efforts and the resources is to imagine that soundboard in a mixing studio, right? In a sound studio, and that mixing board. We've seen those images of that vast board with all the levers and the dials and whatnot. And we have to find that just right mix for your particular situation. So it might be a little adjustment of this lever, a big adjustment of this lever, turning this dial on, turning that dial off. Each family's needs a little bit of a different sort of everything to figure out their situation and to have it work for your situation. So today's topic is actually an excellent example of this. We're going to be talking about alternatives to guardianship. And within each alternative that we're going to talk about tonight, You can have a little bit of it or a lot of it. So there's so much to choose from. Sometimes it's hard to exist on a continuum. That's what adulting is, right? Things are no longer black and white, good guys, bad guys. Now we have all that stuff in between. So anyway, I'm about to start, and I'm going to share screen. Let's go here. Actually, I'm going to share screen. I should have done this in the beginning. There we go. So here's us. You can see our gorgeous pictures here. Caregivers ourselves, we're on this journey with you. And I'm going to say, I'd be remiss if I didn't also recognize you as the caregiver, the decision maker, the interpreter, the manager, the logistics master, and you're actually the person who puts others' needs before your own on a regular basis. So this can be a form of self-care, educating yourself, attending these seminars. So I just want to thank you for coming tonight. I appreciate you. I'm just going to go ahead and start. I'm just going to review guardianship very, very quickly. So here's our agenda tonight, brief review, and then we're going to talk about, I think there are 8 bullet points. We're going to kind of talk about those more in depth, and that's when I hand it off to Bruce. Cute picture. I want some of that ice cream. So just as a quick review, in the majority of states, right, 18 is the next number. If you have a normative 18-year-old, this is a good time to send them off to college and get them adulting and responsible for life. But we no longer have access. If they go to college, we can't get their grades. We can't ask for health information. This is when you're basically and supposedly being able to make all of your decisions. I know that I've got a 30-year-old as well. I'm still like a mom, but for the most part, I can't call up and just demand things and ask things and check in on her finances and whatnot. So each family situation, very unique, and we're going to kind of talk about those alternatives. The laws vary by state. I know we have a client family. They moved from New Jersey to Pennsylvania. They need to get their guardianship reviewed according to Pennsylvania statutes, laws, and whatnot, right? So even just moving across the river, I want you to think about the fact that some of these other alternatives can be far more flexible than guardianship, for example, or if someone's going to be moving, something to think about. Guardianship, there's the continuum, full, limited, joint, full guardianship. You can really think about it, very, very broadly. All rights are taken away. Limited, you can still maintain some of those rights. So here I'm going to hand off to Bruce. He's going to be talking about alternatives, and we're going to go through these one by one. So Bruce, when you're ready, you let me know, and I will hit the first slide.
Okay. All right. So just again, thank you. I just want to echo Susan. Thank you all for being here tonight. I did see a few new people join us. So we are just getting started. Please, since it is such a small group, feel free to unmute or put questions in the chat. We want to be able to answer everybody's questions. Everybody is entitled to a 1-hour free consultation with us as a courtesy to Christine and Melanie for bringing us to you tonight. We can also send copies of the presentation, so you'll have all of our contact information. I know sometimes people are a little shy, sharing or asking questions in a group. Obviously, everything is confidential, and a lot of your questions are very personal, but you are welcome to reach out to us, okay? So as Susan said, there are 8 alternatives to a formal guardianship. And for those of us in Pennsylvania, particularly in Montgomery County, we are hearing more and more that it's becoming more difficult to get guardianship. We're looking for like the least restrictive option for our loved one, okay? Obviously, when we do these lectures, we are our child's guardian until they are 18, right? And some of you may be dealing with with a spouse or partner who is beginning to suffer from dementia or lack of cognitive abilities, and you're applying for guardianship on that level, right? There's different types of guardianships that people would apply for, but we want to look at the alternatives to guardianship. And I'm just going to jump for a second out of order because Susan made a very important comment about when children are in college and you're not able to access any of their information. And for those of you parents on the phone who may have experienced that, even with your neurotypical children, right? The only thing I was allowed to do was pay the bill, right? That I could get through to the bursar's office and they would welcome my call. But, if a child was having a crisis or a problem, they were having issues, get into trouble, whatever, without that power of attorney, we don't have those rights. So we do actually recommend that if you have neurotypical children going out off to college, it probably makes sense to have a power of attorney for them as well. Certainly, at least until they have a spouse or partner or somebody that can take on that role. But I'm going to jump back into the order of the session now, and supportive decision making. And this is something that, again, it is not necessarily recognized in Pennsylvania. So we didn't want to spend a lot of time on this, but just as Susan referenced the family that moved from New Jersey to Pennsylvania, many of us, I know, in our wills and in our documents, we have our children or our loved one potentially living with a relative in another state. So if that is the case, okay, if that is the case, and that again is why there's no cookie cutter answer for us, right? Everybody's situation is going to be different. So, supportive decision making, okay, allows individuals who are able to communicate, okay, and have the ability to make choices. They can have some autonomy, okay? They can retain the right to make their decisions and appoint others to consult with, not necessarily to take charge of, but to consult with. And this is something that can be updated and it can be different for everyone that implements this strategy. But as I said, many states, don't necessarily recognize this as a formal decision-making agreement, okay? So I urge you before, because we were very excited when we both learned about this, because nobody wants to just, when you hear about guardianship, you're completely taking away all the rights of your loved one, right? You really are declaring them indigent, right? Incapacitated. And it can be a very upsetting experience for our loved one as well. Obviously every judge is a little different, and sometimes the way these hearings are done, they can be very demeaning. And if your loved one truly, like Susan explained, the difference between a medically compromised child versus an intellectually challenged, intellectually disabled child, obviously my daughter may not understand what was being said, whereas Susan's son very much would understand what would be said. And might be very, very offended and upset by it. I think we work very, very hard to let our children know that they can accomplish great things. And then immediately once they turn 18, we're going to incapacitate them and take away all their rights. So I think, I really give Christine and Melanie credit for, just bringing this to us and saying, what are the alternatives? Families want to know what options they have. And I will say also, when we get into some of these other things like powers of attorney, and we're going to talk a lot about powers of attorney, but you can name a successor when you have a power of attorney. Whereas with a guardianship, it's several $1,000s, and you cannot name a successor. You can recommend someone, but when we are no longer able to serve as that child's guardian, either by death or my own disability or my own incapacity, the person that we may want to take on that responsibility has to then again apply to be the guardian. Whereas with some of these other options that we're going to discuss tonight, you can actually make a recommendation or even name a successor, which is really quite wonderful. So let's go to the next slide, Susan, if we can, please. Any of us who have children who are receiving Social Security, when you apply for SSI, okay, or SSDI, and again, often, Christine, people have us do a whole lecture on Social Security because it's very complicated. Are you getting disabled adult child benefits? Are you getting survivor benefits? Are you getting a combination of SSI and SSDI? Why was I told I can have $8,000? I was told I can only have $2,000. A lot of moving parts here.
We get that a lot too. Absolutely.
Right?
Yeah.
Right? A lot of moving parts here. But when an individual is not capable of managing their own money, Social Security is looking to have a representative payee. Okay. And the representative payee is typically somebody that's connected to the individual, that has a vested interest in the individual. But there are requirements. You cannot have ever been convicted of a felony to serve as a representative payee. Okay. You have to keep very good records accounting for. You're going to be asked by Social Security to account for what did you use the money for. And they want to see that it was used for housing, lodging, food. Okay. The money can be used for personal grooming, for toiletries, anything for the individual. They do look at, well, was any saved? What was saved? And remember, if your loved one is receiving SSI, okay, or SSDI, there is a resource limit. So you absolutely want to make sure that at any time, if you are being audited, we don't have more than that $2,000 in any account. Some people think it's all accounts. I can have 2,000 in Citizens Bank and 2,000 in savings bonds and 2,000 here. No, 2,000 total. And many of us got a lot of extra money during COVID. Those of us who may have just applied for SSI are getting 6 months, 8 months back payments. Maybe our children, and Bruce, I'm just going to call you out on this, when our children went on our benefits, right? Because we had that conversation. We were both born in the 40s and 50s. When we went out on Social Security, our children became eligible for half of our benefit. Well, every month my daughter has more than $2,000, right? So we have to be very diligent as a representative payee to manage those funds for our children. Okay. And that is something, if I ever got to the point where I couldn't serve or I didn't feel that I could really manage it for my daughter, we can very easily name and go to Social Security another rep payee. I don't have to spend thousands of dollars and go to the state and apply to be a rep payee. Okay. Really just going to the office with ID. They do. I was very impressed that we had a family recently where the individual that they wanted did have a felony, and they would not allow them to be the rep payee. And look, felonies can be of all different levels of I was very, very surprised, very, very surprised. Okay, next slide, please, Susan. Yep. So medical directives and healthcare representation. Okay, so there are powers of attorney or for medical, and there are powers of attorney for financial. And even within these powers of attorney, if you will, you can literally list a number of items for which the individual that you are giving that authority to can make decisions for. You can literally have initialed that I want Susan to be able to decide if I should be tube fed, but I don't want Susan to decide if they should turn off my respirator, right? It can be that specific. A lot of times, if the individual really doesn't understand what they are agreeing to, right, that's a different story. Like sometimes it's very complicated to understand. I saw one the other day about the electronic therapy that they used to do, right? Remember where I guess they still do it, electronic therapy to stimulate the brain, right? Like that was listed in the healthcare power of attorney that we were looking at, right? And the individual had, capacity and understood what was being said. And, experimental drugs, do you want to, and I found that there were times where you might want to be on trials. If there's a drug trial that's going to cure cancer and that might be the drug that's going to keep me alive, well, I may want that. But, the first thing I thought of when I heard of experimental drugs is, oh, they're going to just experiment on stuff on me. I was immediately saying, no, I don't want that. But then when it was explained to me that this could mean like a trial for a new, I'm dealing with prostate cancer right now, and I had no idea there were different forms of treatment for something like that. Right? I mean, I had no idea some of the new things that they're doing. It's not just radical cut. So I think it's very important for us to understand when we are looking at these documents or we're seeking legal counsel. And again, Susan and I are not lawyers, but we guide you as to what is available and what to even ask the lawyer for. Okay. We're not charging $500-600 an hour like a lawyer is to, you can ask us and say, Bruce, they asked us, did we want a durable medical and financial power? Did I want a specific living will? There different lawyers are going to call them different things. It can become very overwhelming. Okay. So please feel free to reach out to us, and we're happy to go over them with you and explain what is being presented to you and what your options are. Okay. I think that I hope that that's helpful. You can be as limited, okay, as just a healthcare representative, okay, to help when when my daughter is in with her doctor. I know that she doesn't understand all the questions that are being asked of her. And so I am allowed to accompany her, okay, and answer those questions before they might do a more private exam. I do step out of the room, but I just know that she doesn't understand. I mean, the first time they asked her if she was sexually active, okay, that was a perfect example. She said yes, okay. When one of her friends put their arm around her, she feel that's they call it a snuggle, right? Like, and again, so it allowed me to explain to the doctor what my daughter was experiencing. Okay, I hope that clarifies a little bit.
Yeah, and sometimes when there are complex medical issues, so in
your case, right?
It's not like the day my son was 18 years in one day, he all of a sudden knew every nuanced thing about his medical history. There was still reason for me to attend big parts of doctor's appointments or have phone calls and that sort of thing. Anyway, I'm just saying a continuum.
Yeah.
Levers, little levers. You ready for the next slide?
Yes, please. Okay, durable powers of attorney. So again, even with a power of attorney, a financial power of attorney, there are some that, like an attorney, in fact, like if we set that up today, you can actually they are immediately effective. Okay. Well, some only when the individual is unable to make decisions on their own, but there are powers of attorney that are effective immediately. Okay. We often see that between husbands and wives, right? That you can, I can immediately now make decisions for my wife. My wife might not like that, right? So she may want it to be a limited power of attorney or a durable power of attorney. Durable, which something has to spring to action when the power of attorney can be utilized. And that would typically be a doctor stating that she is really not capable of making sound decisions on her own. Okay. And these durable powers of attorney will remain in effect until such time that either the individual passes, okay, or if they are able to recover from it. I mean, look, we don't often see that. Usually when we're losing capacity, it only gets worse. But there are times when somebody is going through, especially with a seizure issue, or right, like there are times when, after a period of time and medication and treatment, that maybe we don't have, with the woman that we're working with right now, Susan, right? Like she has done amazingly well. But when she turned 18, she was having seizures constantly. She was absolutely not capable. And now, thank God, due to treatment and medication, and she's doing, God bless her, amazingly well. So, so you want to have the least restrictive type of authority in place. But we are big fans of powers of attorney. Okay. If we go to the next slide, it explains maybe a little bit better the specific powers of attorney. Like maybe I only want Susan to oversee my banking, my financial, okay, issues. Okay. We talked a lot about just overseeing medical issues, okay, or limited medical issues, right? Things that maybe my daughter or Susan's son is not capable of answering, right? But certainly we've not taken their rights away. They have the right to say how they are feeling, okay? And if there's something that they're very much against, then maybe we look at an alternative, right? Whereas with my neurotypical daughter, I'll never forget, she was at Westchester University. Her esophagus had swelled up and cut off her air supply, and she was basically dying and refused to let the medics put an IV in her arm, which would immediately get the medication in to reduce the swelling of her esophagus to save her life. Okay. And I got on the phone and said, I have a power of attorney, and I'm telling you right now, give her the needle. And that took precedent, okay, because she was not making a good decision. Okay. She was not making a good decision. So again, it gave me the right to intervene. If the child is going to do something harmful, you really want to be able to intervene there. So there are specific powers of attorney that, again, when you're looking at this for your child, I think it's very important that you identify what specific powers that you're going to exercise. I'm going to just go out on a limb here. When we talk about special needs, and while we did say intellectual or medical, there's also mental illness. There's also debilitating illnesses. We work with Parkinson's patients, ALS patients, patients with dementia, but mental illness is also a very big area. And I'm sure, Christine, you see this a lot with parents who are helping their children who are bipolar, maybe have schizoaffective disorder. And there are times when the kids are on their medication and they're brilliant. They are just doing fantastic. And there are other times when something goes awry and then they go off their medication and they're just in a really, really, really bad place. Mm-hmm. And I know we get calls from parents all the time that I worry, what's going to happen when I'm not here? Nobody really wants to deal with my child, right? How can we make sure that the bills are being paid, the rent is being paid? And obviously, when we get to the trust section, this is where Plan FEA can come in and really save the day, right? Because they will serve as that trustee for our children. And I just can't tell you how important that is. And you may say, well, I have other children, but you know what? It might be overwhelming to our other children for our child with the mental illness to be asking all these questions all the time. It's better to have somebody else. Okay. Now, again, Christine, you have shared with me, you can have co-trustees, right? Like my son could be a co-trustee with my daughter. But if it becomes overwhelming, you have that ongoing professional management to be able to intervene, and they're not going to take it personally, right? Because they're trained professionals to act in this capacity. So I think, I hope I don't know if I'm hitting a nerve to some people, but this is a huge area, particularly post-COVID. Christine, did you want to add something, or did you want to say
Yeah,
something?
I did have a question I wanted to throw in there while you're on this topic. And I also was gonna, because you brought up mental health,
Yeah.
there are powers of attorney that are specific to mental health decision making that would happen in that world. But when you were speaking about sort of the springing power of attorney, where it only comes into effect when the person is become incapacitated versus the power of attorney that's in effect as soon as you sign it. I just wondered if you could elaborate a little more on the pros and cons there, because I think there's an argument of the protection of the individual's rights
Yep.
by having the springing power of attorney, but it can also create a bit of a bureaucratic hurdle in
Yep.
situations that are emergent. So I don't know if
I
you
agree. I
uh,
agree. I agree. I couldn't
notes
agree
on
with you
that.
more. And, different lawyers have different views on that. And, some lawyers are very much, because I know one of the lawyers that we work with does, the immediate, and people are questioning, well, that means I could just do this. Well, first of all, your spouse is signing off on it, right? And they are completely competent when we are signing these documents, right? You have to be in a very good place to be able to sign these documents. And if my wife's in a car accident and we have to make immediate decisions on the spot, well, there may not be a doctor there to make that decision and to spring it, right? So I can have the authority to say my wife wants to be kept alive no matter what. She never signed a healthcare document. She wants to be kept alive. Okay. Or the opposite, if they're getting ready to intubate me, right, and that's something that I absolutely don't want, then she could say, I know my husband did not want that, right? He just wants to be kept comfortable, right? If there's no possible way for him to recover, he has been brain dead for 20 minutes, he will never, ever be Bruce again, then just make him comfortable, right? Like, so I think, like Christine said, there are really pros and cons to
You
the
made
two
a good
duck.
point here with your when you mentioned that if you're going to do I hadn't thought about this so explicitly, but if you're going to do a springing power of attorney where it's only in effect once the person's deemed incapacitated, that maybe that's a scenario where you really want to make sure you've done that advance healthcare directive
Correct.
so that
Correct.
there is a record of that person's wishes if you're encountering some pushback about what their capacity is and if the power of attorney is in effect yet or not.
Yeah.
So
Yeah. Yeah.
that's good
I
thought.
mean,
So-
and some lawyers won't do medical directives for individuals with intellectual disabilities because they don't believe that they have while they have the capacity to maybe vote, or we don't want to take away all their rights, but they really wouldn't understand the medical questions that are being asked to them, right? So they do more of a combination, giving the authority to the individual, doesn't have to be the parent, but to act and make medical and financial decisions for the individual.
Right.
Go
There
ahead,
was
Susan.
there was a very famous case of guardianship, kind of conservatorship, but you remember Britney Spears, right?
Mhm.
In the news over and over, and how she had to use the court system to break the conservatorship, the guardianship. They had it was a family member had guardianship over not only her assets, finances, and property, but also her personhood, regulating her birth control and having babies and all of these other kinds of decisions, right? And so look at how complicated it was to unwind this. Powers of attorney, even though there's much more nuance, right? It's much more flexible. Life changes, things change. You can't just unwind guardianship by saying I rip up this piece of paper, but you can revisit your powers of attorney as often as you want to. Anyway, okay, I hand it back to you.
Okay. Let's move on then. I mean, were there any other questions about that? I appreciate Christine bringing that up. I think that's very, very important.
Mm-hmm.
Okay. Obviously, we could also spend a whole hour talking about trusts, but often when there are trusts in place, that is it really an alternative to guardianship? It's different. It's taking some of the financial component and naming a trustee, a person to act on behalf of the beneficiary, the individual for which the trust is set up, to make these specific financial decisions for them. Okay. Often the trust is the bulk of the assets that is being left for the child, but it could also be a lot of our children, if it was a traumatic birth injury or a car accident, or some type of a settlement, they themselves have been awarded the money. You may have heard the terms first party trust, third party trust, pooled trust. Obviously, working with Plan and PA, I'm sure you're hearing about trust all the time. But many of us, if we had a child with a traumatic birth injury and the child was awarded a settlement at birth, they are basically put in a first party trust. These are typically government payback trusts. There are lots of restrictions. Any amounts of money that you use over $5,000, you have to get permission for. But there is a trustee that is named in these documents to act on behalf of the individual. Now, it is very interesting with some of the acts that came into place in giving our children some rights, where we now have self-settle trusts. Years ago, an individual, you think about that single Aunt Mary who said, I'm going to leave all my money to Bruce's daughter because she's going to need it. Okay. And meanwhile, she never tells me, obviously now she's deceased and my daughter inherits $500,000. Well, that just jeopardized all the planning that we've done, right? She now is going to lose her Medicaid. She's going to lose her waiver services. She's going to lose all the services that she has until she spends that $500,000 down. And for those of us in Pennsylvania who know that there are 16,000 people on a waiting list for these waivers, she's now going to go to the bottom of the list. Okay. It took us 13 years to get funding for her. So, it's very, very important that you let other family members know that if they are planning on leaving money to your child, that you have a trust, and here's the name, and here's the date, and here's Christine's number, right? Like, there is a trust. And then obviously we can explain if it's a first party trust, third party trust, but a third party trust, anybody can leave money to, right? Anybody can leave money to a third party trust, and you can then name a successor of that trust. But if the individual themselves now inherits the money or has money, or Susan and I are finding out, this has just been a real revelation. Individuals with special needs who work for some of these companies like Lowe's, Home Depot, they have mandatory retirement for the individuals. And whether our kids participate or not, they are putting away 1 or 2% of their salary for them. And next thing you know, they have thousands of dollars put away, and that counts towards the $2,000 limit. And the minute somebody finds out about that, it's a real problem. And so the only way to protect their Medicaid is to, one, liquidate it, pay taxes on it, right? Of course, because they're disabled, we might be able to waive the 10% penalty. But it's just so critical. That money has to go into a first party trust. It has to go into a first party trust because the government's going to want the money back when the individual passes away. Okay. So these are all situations where we may have to make a change. We may have to intervene here and set up these trusts, these first party trusts, to handle, these, what God laughs when we're making plans, right? Like, you don't know if you're going to get hit by a bus. I had a 70-year-old get hit by a bus. She got a $250,000 settlement. 70 years old, she was still on SSI. Her parents never qualified her when she was younger. She was not eligible for DAC benefits. And now all of a sudden, she had this $250,000. We had to do what they called a Medicaid annuity. We did a Medicaid pay down annuity. To meet, we had to stay within the income limits. It was very, very difficult and very complicated. But trusts are wonderful vehicles that we're allowed to have. And I think it's very important. And if it is something that you want to, obviously, you're with Plan a PA. I think you've access to the best to be able to talk about how the different trusts work and how they work for us. But if there are questions, please ask. All right. I don't know if there are any questions or we should move on. I'm being mindful of the time. We have about 13 minutes left, right? This was one that was kind of new to us as well, these protective proceedings, okay, where we can name somebody to basically oversee assets for a minor or incapacitated person. I guess that's less restrictive than a formal guardianship. I'm not taking away all the rights of the individual, but just very specific. It is tailored to very specific needs. And again, maybe these are more complicated medical decisions that Susan may have to make, or maybe these are more complicated financial. I'll give you an example. My daughter does live independently. She cooks, she cleans, but she couldn't tell you the difference between a $20 bill and a $10 bill. They are $2 in her mind. They are each $1. Okay. So when it comes to financial, I really need to be on top of this. Okay. I mean, there are times when she has gone to the mall and I thought she had $60 and she comes home with $2,000 worth of the same sweatshirt, the same t-shirt. And I now have to go back to the store and return everything. And I am often, and I am yelling and screaming and carrying on like a raving maniac. She came home with $1,500 of Tivana. If anybody knows what Tivana is, it's loose tea leaves that are not returnable. But you have to buy a $50 container to put them in and a $200 kettle to, I guess, brew the tea, right? Oh, I went crazy on them. And I said, you had no right selling that to my daughter. But they said, she bought it. And I said, well, I have a power of attorney and you're giving us back all the money. If you want me to stop screaming and getting shame on you over here in about 5 minutes, you will give me back all my money. So these are examples of sort of like protective things that we can implement if we're not looking to do a full guardianship or a full power of attorney. And I think, Susan, in that the original slide that you had up, while you were chatting, it did talk about the difference between limited and, the different types. I think it was like the second slide maybe that we had up. Type limited, the next one, full, right? Full rights are completely taken away. Okay. Limited, where some of all rights are maintained.
Yep.
Okay. And the joint, where more or than one individual can share the authority, which is nice. Usually between like parents. I mean, we find even in divorce situations, we've been doing a lot of collaborative divorce work where there's an individual with special needs. The couple may have fallen out of love with each other, but they love their child and they have a joint guardianship over the child. But sometimes it is limited and sometimes that's better. I mean, look, again, every situation is different, but I think it's sometimes it's more easy to accept, if you will. All right. I'm sorry, Susan, to make you jump like that, but the last is this parental power. Okay. And I think this is when, obviously, a parent is appointed, okay, as a power of attorney over the money for the child. Okay. Obviously, in accordance with the IRS codes and state laws. A lot of these things, like I said, are state specific. And so you may want to just check if you know that your child is going to be living in California at some point, or we just worked with a family, they were moving to Indiana. And I said, wow, that you better make sure that the documents here, well, Susan herself even moved here from Chicago, right? Little tweaks had to be adjusted, in some of her documents. Family that we were talking about from New Jersey to Pennsylvania. Like I said, she was completely incapacitated when they were in New Jersey and they had a full guardianship. Lo and behold, through treatment and therapy and some amazing surgical procedures, this young lady, you would never know that she had a seizure disorder. You would never know. Okay. And you know what? We want to be able to give her some rights. And when her mother told us the other day she can walk around the block by herself, I started crying. I mean, like, think about it. This kid is learning in her 30s to be, to grow up again. She's 4 years old. She's learning how to walk around the block. It was very emotional. Okay. But we still had to now go back to New Jersey, Pennsylvania. What do you require? What do you require? How do we do this? It's very, very involved. Okay. So I think, you know, starting with the premise of, hey, there are alternatives to this, right? There are alternatives to guardianship. Obviously, if financial is a consideration, a power of attorney is a couple $100. It's a lot less expensive. Like I said, you can name a successor with a power of attorney, but you don't want to put yourself in a situation where if it's contested and a judge says, you know what, Bruce, your daughter really didn't know what she was signing, and you just did this to whatever reason, you know, don't do it just to save the money. Okay. And again, it's not something that has to happen until our children are 18. And I often say to families, when we apply for SSI for you, you're going to get typically 6-8 months back payment. So use that for the guardianship. Use that to pay the legal documents. Use that to start your plan with PA, right? Use that to start your trust with the plan of PA. We are finding you the money to implement these resources that are so needed.
Mm-hmm.
So I think maybe that's a good place to stop and open it up to any questions. And please, Christine, if you have stuff that you want to add, you know, we welcome that. We really value that.
I have a question, if I may.
Please.
I have a son who we have full legal guardianship, and you know, I'm the representative payee. He has a first person trust or first party trust through plan, and we also have a third party trust.
Mm-hmm.
So I'm the legal guardian, and we're in the happy situation where my son is doing well, and I'd like to get out of the guardianship. So my question is, can I do that without an attorney, or do I need an attorney to end the guardianship?
So, I mean, Susan, feel free to chime in. I mean, but we have seen people that go on the state website. I mean, I'm not going to tell you can't. You can go.
Mm-hmm.
What county do you live in, Bruce?
Montgomery County.
Okay, you can go on the Montgomery County website, and there are forms to, you know, you can actually petition the courts and start those proceedings on your own. Okay. But, you know, often people, you know, need counsel, one, because it's overwhelming and they don't know how to do it. But I mean, I guess if you are contested, you know, certainly if it gets to a situation where it's being contested by the judge, I think if ever there was a time to do it, now probably is, because I know Montgomery County is really trying to discourage guardianships, right? And trying to give the least restrictive. You know, we can talk offline, go on the website and take a look. Again, you know, we typically are referring people to counsel, but I don't want to tell you can't, because people have done it.
Okay, thank you. Mm-hmm.
All right. If you go on the Montgomery County website, just look
Mm-hmm.
for, you know, guardianship and look for the forms, and it should give you forms to, you know, uncouple, you know, I mean, I'll take a look also. I think we're going to get everybody's email. I could email it to you.
Okay, that would be wonderful. Thank you.
After the lecture. Yep, our pleasure.
Yeah, thank you, Bruce. Mm-hmm.
Yep, you're very welcome. Anybody else have any questions? That was a good one.
Martis.
So you're recommending that you have both a first party trust and a third party trust, so that if somehow some immediate money came to a person,
well,
that
remember, you can't set up a first party trust after age 65. You can't fund a first party trust after age 65. And what we're seeing, okay, more and more, is that our kids have this other money. My mother, Martis, had $15,000 of US savings bonds in my daughter's Social Security number. I never knew it till I went to Social Security the first time, knowing what I know, thinking that I knew everything, right? And the lady keyed in her Social Security number and she said, "What are you doing here?" I mean, and we had to liquidate it and get rid of it, okay? But what if I wasn't alive, right? What if I wasn't alive and my kids or somebody else was trying to get my daughter set up for benefits, and they said, well, you need to put that money in a first party trust because that's her money,
Mhm.
right? Or the woman that got hit by a bus. Okay. Okay. We couldn't set up a first party trust because she was 70 years old. Right. Again, I don't want to tell everybody to go run out and do it. Obviously, we want people to educate their family to put the money in the third party trust, right? Leave the money to the third party trust. But Martis, how often do we talk to other family members and go around the room and say, Susan, how much are you leaving Amanda when you die? Right? Like, and Martis, how much are you leaving Amanda when you die? But I will tell you, my niece at Thanksgiving said, Uncle Bruce, I named Amanda beneficiary of my 401k. And I said to her, Lori, after I stopped crying, I said, Lori, we got to go upstairs and go online, because now you can go online for everything, and change the beneficiary to the Amanda Sham Special Needs Trust dated August 2nd, 2002. Here's the tax ID number, because Amanda can't have more than $2,000 of assets. But if I would never have known that, Martis, and Lori died on her way, okay, home to New York, and Amanda got that $400,000, okay, we would have had to set up a first party trust. So
Yep. So we were in our little family, we worked very hard to educate everyone about the third party special needs trust. And I was out, we're all you know, I'm a woman of a certain age, and I'm out with some old college friends. They never had children. And one of them said, "Hey, it's not a lot, but I'm leaving Henry some money." Well, okay, first I wasn't like, "Oh, thank you, that is so kind." No, I said, "No, no, you
you can't do that.
can't do that. You're gonna," and then I used a bad word. You can't do that. You're gonna ruin everything. And so it was, and here I thought I crossed all the T's, dotted all the I's, and I had everything buttoned up. But it wouldn't take much, right? To
Jeopardize
over
it
that,
all.
jeopardize and go over that resource limit issue. And so, like, to your question, it whether people put the trust inside their own wills to become alive at death, or whether it exists out there ready and waiting for whatever, that third party trust, you know, whether it's in your will or whether it exists as its own entity, those are all very personal decisions, and it's family specific. What are your needs? What does it look like? What does the future potentially hold?
I will also just add to that, if you are a family that's already connected to Plan of PA, and you have a third party trust with us, even if it's future funded, Plan of PA does have a type of trust called a pooled trust,
Mhm.
which is a trust that is already written. And it's a whole other topic that we could go on and on about. There's some pros and cons to pooled trusts. But you don't need to hire a lawyer to have that trust. You can just sign on to it and join it. So we've had numerous situations along the lines that you guys have described where a parent dies and we become trustee of a third party trust, and lo and behold, the beneficiary does have some money in their own name that they're entitled to, and we do have the benefit of being able to provide the first party pooled trust as a quick solution to that. What can sometimes arise as a challenge is the capacity of the beneficiary to sign that money over into the pooled trust. And that is where it also can be really helpful to have that financial power of attorney, or we would be going the route of, like you were describing, those protective orders where there's a temporary appointment by the court to help someone make a decision like that. But if you have taken the step to become a part of the Plan of PA organization, there is some peace of mind that even if you haven't fully covered that base, we have some options to jump in there should the need arise.
Yeah, that's huge. That's huge.
Absolutely.
Any other questions or concerns? As we said, you're welcome to write to us. I mean, Christine will give you our contact information, copies of the presentation. Everybody is entitled to a free consultation with us. So feel free to reach out. Our number's on the front page of the presentation, and we're happy to speak with you or get you whatever information that we can. If you heard something that you'd like more information about, feel free to reach out and we'll get it over to you. I really appreciate everybody jumping on, and some of the new people that just came on. Sherry, welcome and thank you.
I'm going to stop sharing here.
Thank you so much, Bruce and Susan. We really appreciate the presentation and all your thoughtful additions from your experience. It really adds some color to the topics that we're covering. So
It's our pleasure. It was our pleasure. Thank you for having us.
yeah. And thanks everyone for
you.
joining.
Okay, everybody, have a great
Thank you.
night.
Thank you, Christine. Thank you, Bruce. Thank you, Susan.
Thank you.
Good night.
Good night.
Take
Good night,
care.
everyone.
Night.
Good night.